noise to it. We have load shedding here till around 6 o'clock, so it's not going to bother us too much. Not everyone might get it, but if you do get a bit of a background noise, just know that it's probably nothing wrong on your side. It's probably the inverter coming through on my side, as my mic is obviously on. But right, ladies and gents, we said in terms of what our aim is for this week, we said last night we want to look at intestate law, and this evening we want to look at testate law. Now, ladies and gents, just to remind everyone again, at all stages we need to be muted, and there will be a stage where I will open the floor for questions. Please keep in mind that if there was something you wanted to ask me last night that we didn't get to, you are welcome to ask me today when I open the floor for questions. Ladies and gents, the whole concept being the questions are not just open for what we're covering on a specific evening, it's also open for things that happened previous evenings if I did not get to your particular question. Right, we'll get going with testate law before we open the floor up for questions a little bit later. Now, ladies and gents, last night we had a look at intestate law, and the whole concept of that is, what are the rules that we need to follow? What are the rules that we need to follow if someone passes away without a valid will? This evening, what we are going to be looking at is what happens if someone passes away testate. So what does that mean? If you pass away with a valid will. So it's on the other spectrum. Now, ladies and gents, what I do not want any of you to ever confuse in the exam, please do not confuse testate law with intestate law. They are two completely separate things. What we learned last night, or what we went through last night, was purely only for intestate law. What happens if you pass away without a valid will? In other words, tonight we are looking at what happens when you pass away with a valid will. In other words, you die testate. It's on the other spectrum of things, right? Now, when a person dies testate, as we've already established, it means it's when they die with a valid will. Things are a lot easier, ladies and gents, because that will obviously tell us what we've got to do. So we don't need to apply any rules or try and interpret who gets what. No, the will should be clear enough and should obviously indicate who is supposed to inherit. So we'll simply be following that rule. Now, we should all know from varsity, I believe obviously testate law, I think it was called law of succession, if I remember, is a compulsory subject that we all had to deal with. So we should have a basic understanding of testate law nevertheless. But we will remember the starting point for testate law was that in South Africa, at least, we have what we call freedom of testation. Now, ladies and gents, for purposes of this evening, when I'm speaking to you about things, I believe it is in your best interest to maybe take notes about it or little reference points to remind you to look at things, because it is purely theoretical testate law, not something that you need to understand, but it's something you need to study for in an exam. So obviously when I'm speaking to you about different aspects of testate law, I'm trying to focus my energy into what I believe is most relevant at the end of the day. Now, we said we have freedom of testation. What does that mean? I think that term freedom says everything. It means that we can leave what we want to who we want. Nobody can tell us you can't leave this for that person and you can leave it for that person. No. Freedom of testation means you can pass away and leave everything for John down the street and leave nothing for your family members, for argument's sake. You are 100% allowed to do that. Remember, the only time we worry about blood and family members and who inherits what, that's when you die without a valid will. That's intestate law. But the moment you have a valid will, then all of that is irrelevant. We just look to see what your will says. And there is no restrictions placed on us in our will. If you look at the rules and the discussions about it, it actually specifies, that we have freedom of testation as long as we do not do something that is illegal or immoral. Now, let me sort of explain that concept to you. I think illegal speaks for itself. We know what's legal, we know what's illegal. That's criminal law. We can't, in any circumstances, commit an illegal act. But the interesting concept there is the immoral part. I think you would agree what is immoral for one person might not be immoral for another person. I mean, everyone's moral compass is sort of set at a different angle. Now, the law says we have freedom of testation, which means we can leave what we want to who we want. So morality has nothing to do with that. When they speak, we have freedom of testation as long as we don't do anything that is immoral. They don't mean about who your beneficiaries are. They don't mean that it is immoral to leave everything for John down the street and nothing for your family. That's not what immorality has to do with. When you see the term immoral, it specifically is referenced towards conditions in a will. You might have come across some people create a will and they leave things for certain people, but they put a condition in place. You can inherit as long as you do 1, 2, 3, 4. That's where the immorality comes in. These conditions that you leave in your will, that certain people must do this before they can inherit, that is where we decide whether or not those conditions are moral or not. Now, there is no hard and fast rules, ladies and gents, to what is moral and what is immoral. The law doesn't govern that aspect at all. So usually if someone challenges the will based on morality, it is something that ends up in the High Court. I mean, any challenge about a will must by law go to the High Court, and the judge would have to make a decision. Based on things that I've seen, I can give you an example of when something was declared immoral and another example of when something was declared moral. There was a will that was created and a person left an inheritance. I can't remember if it was for his son or his daughter. And he said that they can inherit, but only once they've completed their after-school tertiary education. Now, their child actually went and challenged the morality of that and said that it is immoral to force me to study after school before I can inherit. So I should just receive the inheritance free for meeting that condition, in other words. And the court actually looked at that condition in the will and said, well, from the evidence before us, you are mentally capable of going to study. Secondly, the finances have been put in place so that you can go and study. And thirdly, it was clear your parents' intention behind this condition was a good one, trying to ensure that you get some form of education after school. And the court actually dismissed that application and judged that that condition was moral. It is moral because it was in the best interests of that child. There was another scenario, another case where I believe a father left an inheritance for his daughter. But in the will, it said that his daughter can only inherit if she married this certain guy. Now, the daughter went and challenged the morality of that, and the court ruled that it is immoral to force someone to enter into a marriage with a certain individual. So at the end of the day, the court ruled that his daughter could receive the inheritance without meeting that condition, because that particular condition was immoral. So when you read up on freedom of testation and you see the terms morality or immorality, it's got nothing to do with who you leave things for, but it has to do with whether or not you put conditions before they can inherit, and whether or not those conditions are regarded moral or immoral. Now, the question that we probably need to ask ourselves is, if we have freedom of testation, and if that means we can leave whatever we have to whoever we want, there's no restrictions put on place, why does the law say a will must be valid? In other words, what is the requirements for a will to be valid? If we have freedom of testation, surely we can do anything and say anything. That's correct. However, there are certain formalities that the will needs to comply with before it is regarded as valid. Now, a lot of these formalities we should already be aware of. I do stress it is important to know what formalities need to be complied with before a will is declared valid. Let's go through those formalities quickly, and let's just make sure that we're all on the same page there. So what are the requirements or the formalities for a valid will? Well, first things first, a will needs to be in writing. I think we all know that. You cannot have an oral will. A will is only valid if it is in writing. Secondly, I think we all know that the will needs to be signed by the testator, hey, or by the testatrix. If you look at the requirements over there, it's quite clear. It says the testator needs to initial each and every page of the will and needs to sign in full on the last page of the will at the end of the will. It's important you say it like that. If you do get a question like this in the exam, where does the testator need to sign on the will? It's important that you indicate they need to initial each and every page and they need to sign in full on the last page of the will at the end of the will. In other words, at the bottom, eh? Important you use those words at the end of the will. It's specifically looked at that those words are used if that question is come up. All right? So that would be the second requirement. The testator needs to sign this will. The third requirement, which I believe we are also all aware of, is that the will needs to be signed by two competent witnesses. Now, ladies and gents, what I find interesting is that the rules say that these two witnesses only need to sign on the last page of the will, at the end of the will. The testator needs to initial every page and sign on the last page, but these two witnesses only need to sign on the last page for a will to be declared valid. Now, ladies and gents, at my office, if we have a will, these two witnesses, I let them initial each and every page as well. But the fact that I do that does not make the will more valid or less valid, because the rules are clear. Testator must sign every page, but the two witnesses only need to sign the last page for that particular will to be valid. I would go on to a fourth requirement, and the requirement is that the testator and these two competent witnesses, they need to be signing the will all in each other's presence. So the witnesses must see the testator sign the will, and the testator must see the two witnesses witness that particular will. Very, very important for fraud reasons, ladies and gents, because if someone ever does question any fraud on the will or whether someone faked a signature, the first thing the courts are going to do is contact these witnesses and bring them in to testify in court so that they can confirm under oath whether or not they saw that testator sign the particular will. That's why you'll see in wills by the two competent witnesses where they sign on the last page, you'll pick up that they put their cell phone numbers and their address and their identity numbers, all that important information, so that if they are ever needed later to confirm that they saw the testator sign the will, we are able to contact them, or worst case scenario, able to do a trace on them, because we have relevant information to do that, so we can get a hold of them. So that is what makes a will valid, right? Very important. In writing, signed by the testator, signed by the witnesses, all in each other's presence. Now, ladies and gents, you need to be 16 years or older before you're allowed to have your own will. I think we should know this. Interestingly, to be a competent witness, you only need to be 14 years or older. So anyone 14 or older may be a witness to a will. I wish to take these requirements one step further. I want to pose you a different scenario. It may happen that a testator or testatrix is unable to sign their own will. This may happen. I mean, I can think of two different scenarios. One might be because of a physical impairment, or ultimately you lose control over your bodily functions. I mean, at all stages, you obviously need to be mentally sound of mind, but it may happen that you don't have control over your bodily functions. I can give you an example. I remember a will I did years ago for a lady that was in hospital. Nothing wrong with her, mentally sound of mind, but she was shaking heavily. So we tried to let her sign the will, and it turned into a scribble because she couldn't have control over the pen. And obviously that will could be questioned because it's obviously not her signature. So we had to let someone else sign on her behalf. All right. So what happens if you encounter a situation where the testator is unable to sign their own will? Ladies and gents, in such a situation, that will then need to be commissioned by a commissioner of oaths. So that particular will need to be commissioned by a commissioner of oaths, and the commissioner of oaths needs to expressly state on the will, they need to say that they have satisfied themselves with the identity of the testator. So the commissioner indicates, number one, that they are satisfied with the identity of the testator, and secondly, that this is indeed the true will of the testator. This is indeed the true will of the testator. Because remember, someone else has now signed the will on the testator's behalf. It's a problem. That's why the commission of oath comes in and says, right, yes, someone else has signed this will, but I'm under oath declaring that this is the will of that person. I'm satisfied with the identity of that person, and this person has confirmed that this is their true intentions behind the will. So if you ever come across a scenario like that, please ensure that that is done. Otherwise, your will be declared invalid. Ladies and gents, just a reminder, let's just make sure we are muted. I am getting some sounds in the background. Right. So that is what makes a will valid, ladies and gents. Important we know this. Without that basis, we obviously do not have a valid will, and it becomes a problem. Right. Now, ladies and gents, when it comes to testate law, the Wills Act 7 of 1953 is your best friend. I mean, it sets out everything that's relevant, and it's obviously worth a read, ladies and gents, before you enter into the exam. Now, I know this question tends to pop up quite a lot, so I thought I would just address it straight away. And the question is, what about electronic wills? Now, ladies and gents, I am very nervous when it comes to electronic wills. If you go and look into the case law of it, you will see mixed results. You will see electronic wills that have not been declared valid by courts. You will see electronic wills that have been declared invalid by courts, some that have been declared valid by courts. It is a mixed bag. As a rule of safety, or to rather err on the safe side, I like to stay away from any form of electronic will because case law is very 50-50 on it. The basic principle is, even if you have an electronic will, it needs to meet the requirements or the formalities for a valid will, which was what? We've just looked at it. Must be in writing, must be signed by testator, initialed every page, signed in full on the last page, and must be signed in full on the last page at the end of the will by two competent witnesses. There has been instances when electronic wills have failed because the courts, is not happy that the requirements have been fulfilled. There's been other instances where the courts have been happy that this did indeed display the true intentions of the testator and they've allowed the electronic will. So I'm just going to say, from my perspective, I like to stay away from it. I'm not saying it is going to be declared invalid if you come across an electronic will, but I'm telling you that you are playing with fire if you start to enter into a whole bunch of electronic wills or do electronic wills for clients and so forth. Right. There are two specific sections from the Wills Act I think is very, very important, ladies and gents. I want to just discuss it with you. The first one is section 2B, capital letter B, of the Wills Act. we need to know this section. Now, I think as a point of reference, I want us to understand this. We have freedom of testation with the will, meaning we can say what we want, do what we want, as long as it's not illegal, immoral, as we discussed right at the beginning of the lecture. Everything we are learning tonight is what we call common law. What is common law, ladies and gents? Common law is the law that takes over when the contract is silent on something. So if our will does not specifically specify something, we look at common law. Okay, that's why we need to know common law. And I believe if you do not know common law, then you are unable to draft a proper will. My reasoning is, you need to be able to look at your client in the eye and say, I've looked at your will, I'm satisfied, blah, 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 blah. However, there are certain things in your will that are silent or has not been expressly stated. Please understand that common law says the following. Do you agree with common law? Are you happy with it? If your client says that's fine, great. Your will is 100%. If your client is not happy with what common law is saying, then you obviously need to change it. You can change common law as long as your will expressly mentions what needs to happen. But if your will is silent on a point, then common law needs to take over. So let's look at a couple different aspects of common law. You'll actually see last night we already covered one of them, but we'll come to it now. So let's look at section 2B of the Wills Act. Now, ladies and gents, you can put it in your own words. You know, I just want to make sure you understand it, so I'm going to explain it to you. Section 2B deals with marriages and divorce. Okay. Again, everything in the Wills Act is pretty much based on assumptions. Now, let's make an assumption. Let's assume that if you are married, there's probably a very good chance that your spouse forms part of your will. I think that's a safe comment to say. If you are married, you probably have included your spouse in your will. You probably want to leave them something if you pass away. I mean, that's quite normal. But should you and that person no longer be married, it's probably also a safe assumption that you probably don't want to include them in your will anymore as well. I mean, that's just the way it goes. And, you know, again, I use the term assumption because, you know, one shoe doesn't fit all. Everyone might have a different perspective of it. But needless to say, we are running off what common law is saying and not what we are thinking. Okay. So the question came in, what happens if I'm married and me and my spouse divorce? Okay. When I say divorce, I do not say I'm now serving you with a divorce summons or I have the intention of divorcing you. What does divorce mean in the eyes of the law, ladies and gents? That's when we are in court and the court grants the decree of divorce. That's a divorce. So I'm referring to the day we are legally divorced. There's probably a good chance that my spouse was included in my will. All right? Now, what happens if tomorrow I die? They're going to look at my will and they're going to see my spouse in the will. But the problem is that common law says, well, you probably don't want to let her inherit anymore because you're no longer married with that person. So it's assumptions that the law is starting to make and say, well, because you're divorced, you know, good chance you probably don't want that person to receive any part of your inheritance anymore. Again, it's an assumption. It's not guaranteed, but it's an assumption that common law is making. So what they've went and done with section 2B, if you read it, very interesting. It says, if you divorce, there's a 3-month window. Okay, very specifically a 3-month window. They say that if you divorce and you die within 3 months after date of divorce, so within 3 months after date of divorce, the assumption is you probably have not had enough opportunity or enough chance to go and amend your will and exclude your ex-spouse from your will. So what are they actually saying? There's an assumption that I no longer want my ex-spouse to inherit because we are now divorced. But because I've died within 3 months after date of divorce, I haven't had enough chance to remove my ex-spouse from my will. So what does the law say? The law says my ex-spouse will not inherit, because it is assumed that you no longer want your ex-spouse to inherit because you are divorced and you have not had enough chance to amend your will. So if I have a will that says my spouse must receive R1 million when I die, we go and get divorced in court today. I died 2 months from now. I haven't went and amended my will. My ex-spouse will not receive that R1 million because common law says that we are now divorced, so I do not want her to inherit that money anymore, and I have not had enough chance to amend my will. But it also works the other way around. What happens if I die longer than 3 months after date of divorce? So let's pose this scenario. I get divorced in court today. I die 4 months from now. Okay. Now they read my will and they say, okay, when I created this will, I was married and I gave R1 million to my spouse. But now this person and their spouse divorced 4 months ago. Now the question is, must my ex-spouse still receive the inheritance? What does common law say? Common law says, Carl, you have 3 months window period. If you haven't amended your will after 3 months after date of death, the assumption now changes. It is now assumed that you have had enough opportunity to amend your will. So clearly, you still want your ex-spouse to inherit, because 3 months was enough opportunity after date of divorce for you to go and amend your will. So in my first scenario, when I died 2 months after date of divorce, my ex-spouse got nothing. In my second scenario, when I died longer than 3 months after date of divorce, my ex-spouse still inherits, because I have now had enough opportunity to amend my will. Now that is what common law says. How many wills have you seen that speaks about this? Not a lot, actually. Not a lot of the wills I've looked at. It's silent on this. So people who are married and get divorced and have a will don't even know that if they die within 3 months or after 3 months after that, that this is what's going to happen. So by knowing common law, I can go to my client and say, look, I see you are married. I know you don't intend on ever getting divorced, but this is what's going to happen if you get divorced. You die within 3 months, your ex-spouse is going to receive nothing. If you die after 3 months, your ex-spouse will still inherit, because that's what common law says. Then you can pose that question to your client, and you can say, do you agree with that? Most of the times, ladies and gents, when I've posed that to my client, they say they do not agree. Some will say, you know what, if my will says you inherit, please do not make any assumptions on my behalf, let the person inherit. Others say, look, if we divorce, they should automatically be excluded. Right? Everyone has a different perspective. So what do I need to do if that's my client's perspective? I need to create a clause in the will that speaks about this, that says that if we divorce, my ex-spouse is automatically excluded. Or if we divorce, please let my ex-spouse inherit if their name is there. Do you see what I mean? You can change common law in your will. But where the will is silent, common law takes preference. That is section 2B of the Wills Act. Very important, ladies and gents. Section 2C of the Wills Act is also something we need to know. And there's 2 particular subsections from section 2C that I want to discuss with you. Again, this is assumptions, and like I said, one of them you already know. Now, what does section 2C speak about? Section 2C says, if you leave an inheritance for someone and they predecease you, now you recall we spoke about this last night, eh? What did we say if someone predeceases you? We said if someone is predeceased, who receives the inheritance? their kids step into their shoes, right? It goes downwards. You'll see when you look at your notes, they speak of the word per stirpes or per stirps. That means down to your kids. So 2C says there's an assumption if you leave an inheritance for someone and they have predeceased you, if they have kids, those kids can step into that person's shoes and claim that inheritance. We know this. We know this. Okay? So you see 2C applies to both testate and intestate law. So testate and intestate are lapping over there. But in general, it's two complete different things like we already discussed. There's another element of 2C we need to know. Okay, so we know if you are predeceased, your kids can step into your shoes. But what happens if someone is renouncing their inheritance or repudiating their inheritance? What does it mean to renounce or to repudiate? It means you're saying you do not want the inheritance. So for those that were unsure about it, let's say I have a will, and in my will it says John must receive R1 million when I die. When I die, John needs to indicate whether they accept the inheritance or whether John is going to renounce or repudiate the inheritance. If John decides to renounce or repudiate the inheritance, that means that John is saying, I do not want the inheritance. Now, this happens sometimes, ladies and gents. It happens sometimes that certain beneficiaries do not want to inherit anything from the testator. So the moment someone refuses or declines their inheritance, the question is, who does that inheritance go to? Who must receive it? Now, section 2C says that if someone renounces an inheritance, then the surviving spouse of the deceased person, not that person's surviving spouse, the deceased person, the testator, their surviving spouse will then receive that inheritance. So know the difference. If you are predeceased, obviously you cannot receive the inheritance, so your kids may receive the inheritance on your part. However, if someone renounces or repudiates the inheritance, that inheritance will then go to the surviving spouse of the deceased person. Please, ladies and gents, they bring this into the exam in different ways. I told you section 2C, this applies for intestate and testate law, ladies and gentlemen. If you receive a question and it's intestate for argument's sake, and someone renounced their inheritance, please remember, give their cut to the surviving spouse of the deceased. If someone is predeceased, give their cut to the kids of the predeceased person. All right. So section 2B and section 2C is very, very important, ladies and gents. Right. A couple other aspects about testate law that we just need to know. And just make sure we know what forms part of it and what doesn't form part of it. From a lawyer's perspective, an interesting aspect of testate law, well, I find to be very interesting is what do people do with their immovable property? Now, you can think for yourselves, the largest type of inheritance that someone can receive is probably a house. I mean, in general, immovable property is valued more than any movable property. I mean, to receive a large sum of cash is a different story. But from an asset perspective, your immovable property seems to be the biggest type of asset that a beneficiary can receive. And it's important that you chat with your clients about how this is going to be. What I've picked up in law is that if you're leaving your immovable property to more than one person, it can sometimes create conflict. I mean, let's say I leave my immovable property, my house, to my 4 children, for argument's sake. What happens if my one child says, right, let's take this property, let's sell it, and let's divide the money? Then my other child says, no, let's lease it out and we share in the rental income on a monthly basis. And then my other child says, no, let's go and live in it. You see, we have a problem because that property cannot be leased out or cannot be sold without the consent and signatures from all the rightful owners of the property. It can create quite a debate and quite an issue and quite a fight amongst the beneficiaries. So you need to explain this to your client as well. Indicate, perhaps you might want to put a clause in. What I've seen some clients do is they put clauses in that says, look, if the beneficiaries cannot agree on what to do with the immovable property within 12 months after my death, then the property must be sold and the proceeds divided amongst the kids. That could be a nice safety net. I mean, I've seen other people that say, well, let's do a usufruct. I have 2 kids, so let's make the one kid the owner and the other kid a usufruct holder. I mean, I'm sure we remember the term a usufruct. A usufruct is when you give someone the right to use something. I think in varsity, they use the words the right to enjoy the fruits of the property. Now, that might seem like a quick fix. I mean, especially, let's say if we had a farm, if we make one child the owner and the other child a usufruct holder, it means both my kids can at least earn income off the farm for the rest of their life, because the usufruct holder, can also use the property. However, if you go into depth, you will see that this is also a problem. A usufruct can be a problem, ladies and gents, because technically speaking, a usufruct holder is someone that has the right to use the property, and that right is not limited at all. What it means is, if me and my brother now, let's say my brother's the owner and I'm the usufruct holder, if we're farming and let's say we're farming cattle and he's got his cattle on the one kraal and I've got my cattle on the other kraal. Tomorrow I decide I want to use my brother's kraal as well, and I chase his cattle out of it and I put my cattle there as well. My brother, as the owner of the property, cannot do anything about it because I have the unlimited right to use the whole property. The owner has less rights than the usufruct holder. It's actually a scary concept if you go into depth. So even the usufruct thing can be an issue, and you often, and I use the example of farms because the law on agricultural property is a bit different. You can leave immovable property to 10 people if you want, but you cannot leave agricultural property to more than one person. That's the law. Agricultural land, for example, farming property, or farming lands, falls under the definition of agricultural land. And the rules are agricultural land cannot be owned by more than one person unless, obviously, you are married. That's a different concept. But unless you obtain consent from the minister. Very difficult to obtain consent from the minister, ladies and gents. I mean, I know people who's requested consent, and 5 years later, they still haven't received any word back from the minister in that regard. So that's also a game I wouldn't necessarily want to play or leave things up to chance. So then you'll often find with farming property, people do things like usufructs, because I can make the one the owner and the other one the right to use it. But as I've already mentioned, usufructs can also be dangerous. So I would usually recommend that if you're not sure what to do with your immovable property, rather put it into a trust. Make the trust the owner of the immovable property, and you make your kids the beneficiaries of the trust. That's something that you could possibly do. Or you open a company and you put your property into the company and you make your kids the shareholders or directors of that particular company. So there's ways around these things, ladies and gents, and these are discussions you need to be having with your clients, especially if they have immovable properties and more than one person they want to leave it for. This type of discussion is very, very relevant. Again, as I said right from the get-go, you don't have to follow common law, but as long as you understand it and you understand consequences of certain actions, you can amend it in your will and make it in such a way that you sort of leave no stone unturned. So from a legal perspective, you've got to understand that agricultural land cannot be left to more than one person, though. Pension funds is another interesting concept. Pension funds are excluded from a person's deceased estate. What is your deceased estate? Your deceased estate is everything you owned as per your date of death. Now, obviously, you might have a pension fund that's maybe worth 3 million rand. However, that pension fund does not fall into your deceased estate the day you die. Everything you own does, except your pension fund. Pension funds and retirement annuities. Certain policies, but we'll have that discussion around Thursday this week, because that's very important. But we're going to still work our way towards that. For now, I want us to understand pension funds, retirement annuities do not form part of your deceased estate. It is excluded. And for those who are unsure why I'm saying this, the reason is when you take out a pension fund or when you take out a retirement annuity, you need to elect beneficiaries. Now, obviously, you are the beneficiary of your pension fund or your retirement annuity. That goes without saying. It's your retirement plan, obviously. But the point about electing beneficiaries is what happens if you die? Who must receive your pension fund? That is why we elect beneficiaries. So if you die before cashing out your pension fund or before cashing out your retirement annuity, the value of your pension fund or the value of your retirement annuity is paid out to the beneficiaries that you elected when you opened your pension fund or when you opened your retirement annuity. So that money cannot form into or not form a part of your deceased estate, because the moment you die, it is paid out to the beneficiaries. Well, I say the moment you die, if you look at it, it takes probably about 3 or 4 months, but it is paid out to your elected beneficiaries. That money never comes into the deceased person's deceased estate. So know that pension funds do not form a part of your will. So don't even speak about it in your will, ladies and gents. It's not there. Whoever the elected beneficiary was when you took out your fund, that is the person who's going to receive the proceeds of that particular pension fund. Right. Now, ladies and gents, outside of common law and things like this, there's other aspects of common law that's very important. Another concept that I think we need to know about is what we call collation. The term collation, again, this is common law, and this is something that applies automatically in a deceased estate, ladies and gents. When I speak of the term collation, the term means there is again an assumption. Remember, we said common law is assumptions. There is an assumption in our law that you would have wanted to benefit all of your children equally. Okay. Now, you might listen to that statement and say, well, obviously, if something's unclear, it's reasonable to make the assumption that you would have wanted to benefit all of your children equally. Okay. I get that. But it's a bit deeper. Let me give it to you by way of example. Let's say I have 2 kids and I tell them, when you turn 18, I'm going to buy you a car. All right. So my oldest child turns 18 and I buy him or her a car. Let's say a car valued at 200,000 rand. Great. I've purchased them that vehicle. My other child is still 16 years of age, for argument's sake. I then go and die. All right. Now, when they look at the will, they say, in Carl's will, it said, his 2 kids must receive his estate. So they look at my estate and they say, right, my estate is worth 1 million rand. So it means 500,000 for the one child and 500,000 for the other child. However, collation automatically applies. And collation is an assumption that my kids should be benefited equally. And Galatians says, if I give both my kids 500,000, they will not be equally benefited, because my 18-year-old child already received a car valued at 200,000 rand. My 16-year-old child has not received it yet. So they are not equally benefited. So Galatians says, we first need to give the 16-year-old child 200,000 rand to put them on the same footing as my 18-year-old child. So I give the 16-year-old 200K. So now I don't have 1 million left, I have 800,000 rand left. Now I take the 800,000 rand and I divide it between my two kids. 400K for the one kid, 400K for the other kid. Because Galatians extends to during the course of my life as well. It says, while I was living, both kids should have been treated equally, and when I die, both kids should be treated equally. It's an assumption that is made. Now, in the example I gave you, you might say, okay, that makes perfect sense, and I agree with it. However, what I've come across in practice is this can be a problem. Ladies and gents, it can be a big problem. Because what happens if I tell the 18-year-old, look, we first got to give 200K to the 16-year-old because you got a car and he didn't. Then we'll take the 800K and divide it between the two of you. What happens if the 18-year-old says, but my brother or my sister received this and I didn't receive that? And then the younger one says, but you received this and I didn't receive that. And it becomes this back and forth fight about, but you got this, but I got this, but blah, 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 blah. Ladies and gents, I've seen this happen. And the problem you have is you cannot wind up that deceased estate if we can't reach agreement about who benefited what. Because the whole point of winding up the deceased estate is giving the inheritances to the beneficiaries. I cannot give it to you if we can't agree on collation. It can become difficult, ladies and gents. Now, that's what common law says. So if your will is silent on it, that's what's going to happen. We have to find out, because the collation only applies to your direct descendants. In other words, it only applies to your kids. So we've got to find out from them, who was benefited in whatever way during the course of the deceased person's life, to try and make sure they are on an equal footing. And that can cause problems. Every time I explain this to my client, I cannot remember one client who said they agreed with collation. Everyone said, I don't want people fighting about my money or my estate when I die. So let's set up the will in such a way that no one can argue any points. So then they say, in other words, I don't want collation to apply. If you got something when I was alive, lucky you. But collation is going to cause a fight. Now remember, we said collation is automatic, hey? So what do we need to do in the will? We probably need to make a heading that says collation will no longer apply, because it's there. It's based on common law. So if we just look at section 2B on the marriage, if we didn't change it in our will, that 3-month rule would have applied. If you look at section 2C, now, that assumption can also be flawed. What did 2C say? 2C says that if you are predeceased, your inheritance goes to your kids. Maybe I don't want your kids to receive anything. I want you to receive it. And I'm thinking to myself, well, if you can't receive it, I'll rather give it to someone else, not to your kids. Now, common law says the kids are going to get it. So I'll need to mention in my will that if someone can't inherit, this is the person that has to take the inheritance. Otherwise, section 2C is going to apply. Think of collation. If I don't mention collation in my will, it's there. It's going to apply. So I need to explain these things to my client so that they can have a will that best suits their needs, because they do not know these things, ladies and gents. There's a lot of attorneys I know that don't even know these things. So it's important we understand these automatic assumptions that are there in our law, because we can change it. We can say what we want. Why? Because we have freedom of testation. And the only way to change these things is to understand what these assumptions are. We can then go and amend it to whatever suits us best. Okay, so you need to understand, this is what collation means, but you need to understand what is negative about it. You need to understand that you can leave immovable property to whoever you want, except if it's agricultural land. But from a lawyer's perspective, you should understand what's the consequences thereto. You need to understand Section 2B, Section 2C, because you need to be able to explain this to your client so that we can change it if we don't agree with it. You need to understand for an exam that a usufruct is the right to use property. But from a lawyer's perspective, you need to be able to explain to your client that yes, on the face of it, that's what it means. However, the right to use is unlimited, and it can create a real problem for the owner of the property. Maybe just from an interest perspective, I remember a farm that was valued at 3.4 million, something along those lines. But that farm had a usufruct over it. So someone had the right to use that particular property. The owner wanted to sell the farm. Now you can't just sell the farm without getting consent from the usufruct holder. So the usufruct holder gave consent and said, you can sell the farm to someone else. However, it is sold subject to my usufruct over the farm. Obviously. Okay. So the question was, what is this farm now worth? I mean, it's worth 3.4 million, but if someone's going to buy this farm, knowing very well that someone else has the right to use that particular farm, it's obviously going to lower the value of that farm because it could be a potential stumble block. So we went and looked at the law and did the calculations to see what that particular farm was now worth if it was sold subject to a usufruct. The value dropped from 3.4 million to 450,000 rand. You could buy that farm at market value for less than 500,000 because it was sold subject to a usufruct. Someone else had the right to use the farm. I think that story that I told you there already puts in perspective how strong a usufruct holder's right is. So yes, you probably don't need to know that for exams, but as a lawyer, it's important you understand that there's always deeper aspects to all these things we read about, and we need to be able to apply it so we can advise our clients in the best possible manner. Now, ladies and gents, if we have freedom of testation and if we understand common law, it means that we can't be wrong when we draft a will, right? Because your will might look neater than mine, your will might be more comprehensive than mine, but my will is not wrong because I have freedom of testation, right? As long as it's not illegal or immoral. As long as I comply with the requirements or the formalities for a valid will, that it must be in writing, signed by testator, 2 witnesses, all in each other's presence, as long as I do that, then I cannot be wrong in my will. But the point I'm trying to get across is that there's a difference between a good will and a bad will. I'm not saying one will's wrong and one will's right, but some wills are better than other wills, because some wills you can see the author of the will clearly understood common law, clearly understood all the little issues that could happen, clearly understood that could create a fight, that could create a fight, and they've already in their will incorporated these things into it and gave clear guidelines as to what should happen if certain difficult situations present themselves. And that is what I want to get across to all of you. Don't draft a will for the sake of drafting a will because you know you are not wrong, because you have freedom of testation. Draft a will with the understanding of what happens if something goes wrong, or have I thought of all the possibilities of things that could go wrong? What's the answer? Have I thought of all the common law aspects and explained that to my client? In other words, is the will drafted to the best of my ability? That's the difference between a good will and a bad will. So if we are able to draft any type of will that we want, and we cannot be wrong by drafting this will as long as we comply with the formalities of a will, what are the certain types of clauses that we should consider when drafting a will, just to ensure that we touch on all the main relevant aspects? I mean, just like any legal document, ladies and gents, you don't just start writing. You divide everything into subheadings and you explain each and every section. And that's what I want to discuss with all of you. What are different things to consider when drafting a will? Different headings. I mean, we want to put each thought process under a different subheading. I mean, otherwise it just looks like one big mess, and it could be difficult to interpret. It could be confusing, you know. So we want to make things as neat as possible, at least. So let's think about these different different clauses we might want to consider in a particular will. And I'm going to mention them to you, and as long as you understand them, you can say what you want about them in your will. I mean, ultimately, it's not my decision, it's not your decision, it's your client's decision. As long as you understand what each clause means, you can explain it to your client, and your client will decide what they want. Now, from my perspective, what are the certain clauses that I like to consider when drafting a will? Well, when I start my will, the first clause I would like to consider is probably what we call a revocation clause, you know, to revoke something. To revoke something means to cancel something. Now, this is a safety clause, ladies and gents. Let me explain what I mean by this. You probably would change your will a couple times during your lifetime because your personal circumstances change during your lifetime. The people you are close with may change during the course of your lifetime, which may impact your will. Okay, I think that's a pretty fair statement to make. So what happens if you create a will and then 10 years later create another will, and 20 years later create another will, and then you die? That means you have 3 different wills. By law, when you die, we need to read all 3 wills because you have 3 valid wills. The problem you have then is your wills probably contradict one another. Now you might say, well, we should look at the last will, but the law doesn't say that. The law says, yes, that last will might carry more weight, but we have to try to interpret all the different wills. That is obviously a mess, ladies and gents. You don't ever want a situation like that. So every time you draft a will, I put a revocation clause right at the front. I have a subheading that says revocation clause, and I simply just say there, I revoke all previous wills. I cancel all previous wills. You want one will to be read when you die, ladies and gents. The last will you created, you want that to be read because you've obviously changed things from your previous wills. You want people to forget about those wills. If you do not have a revocation clause in, it means we have to try and interpret all your wills. So put a revocation clause in when you draft a will for a person. I remember years ago, I drafted a will for a person and I asked them, you know, do you have any previous wills? And they said, no, this is my first will. So I thought, okay, a revocation clause is not necessary. All right. So I drafted the will and the person passed away. When they passed away, one of the banks came forward and said, well, 25 years ago, this person created a will with us. Now we had a problem because we now had 2 wills that were contradicting each other that had to be interpreted. So my client forgot that 25 years ago they created a will. And I didn't put a revocation clause in that particular will. It was an issue. Now, ladies and gents, I'm saying don't make that mistake. Even if your client says this is their first will, just put a revocation clause in it. I mean, it's not going to hurt anyone. And ultimately, it's for your client's own safety. Like I said, you don't want more than one will being read. So that's probably my first clause that I would consider in a will. You know, after that, ladies and gents, there's a whole bunch of other clauses we've got to consider that your client would probably not even have considered. I mean, the next clause I would consider is the executor clause. Who is going to be the executor of the deceased estate? Now, ladies and gents, you'll often see attorneys and banks do wills for free for people. The reason is because they are not interested in making money for doing a will for a person. They want to be the executor of the deceased estate. In other words, when that person dies, you have the duty of winding up the deceased estate. And that's obviously something we're going to discuss a lot tomorrow night, Thursday evening, and Friday evening. and you get paid very well for being the executor of a deceased estate. You receive 3.5% of the total value or the gross value of the assets in a deceased estate. So if you have paid off homes, policies that are paying out, expensive movables that are paid off, I mean, you could easily have someone passing away with a deceased estate value of, let's say, 5 million. Now, what's 3.5% of 5 million? Well, that's 35 times 5. That's 180, 175. Oof, I could be off, but somewhere around 175,000 rand. So for winding up the deceased estate, you're going to make 175K as the lawyer. That's the money you're interested in. That's why people do free wills. That's why banks do it, and banks generate most of their fees from doing wills for people, because the bank, as the executor, takes 3.5% of their estate. So 10 to 1, you're going to want, you would probably do a free will for someone if the client appointed you as executor. But the client obviously has no obligation to appoint you as an executor, but an executor needs to be appointed. So you might have a heading that says executor, and you've got to indicate who is the person that's going to be the executor of this deceased estate. The next heading I might consider is a professional fee clause. I call it professional fee. Some people call it a power of assumption clause. But it's an important clause, ladies and gents, because sometimes someone passes away and you as executor need to close down their deceased estate, obviously, and give everything to the beneficiaries. That's your job. But some deceased estates are complicated. Someone might be running a business and they pass away. You've now got to close down that business for the person in the most profitable manner. Otherwise, you are negligent and there can be a claim instituted against you. But you look at it and you know nothing about this. You don't know how to close down this business. So you might feel that you need the services of someone else to come and assist you, another professional to come and assist you. Or the person passes away, you the executor, and the person leaves behind 2 little kids. Now, these kids have a maintenance claim against the deceased estate. Now, you've got to sit and calculate how much their future maintenance claim is going to be. The one kid is 4 years old, the other kid is 7 years old, and they're entitled to a maintenance claim until they're 18 and possibly more for studies after school. And you've got to try and figure out how much money can these kids claim. That means you have to take into account the inflation rate, the needs of the kids, the current financial situation, blah, blah, blah. You might be incapable of doing that. A lot of people need to bring in an actuary to come and do that for them. So it's another professional person who specializes in things like that. So I like to create a professional fee clause that says, should I require the assistance from another professional to assist me in closing down the estate, I can bring in this professional and the deceased estate will pay for them, because my problem is the money. I can't just bring people in and pay for them from the deceased estate because I don't have the authority. But if it's necessary to close down this deceased estate in the most profitable manner and best way possible for the beneficiaries, so it's in everyone's best interest that I bring in a professional and pay them from the deceased estate, I am able to do so. That is why I put down a professional fee clause. So you can see we're putting down clauses in wills here that are very relevant, but I can promise you your client did not come to see you to speak about a professional fee clause. These are things you have to discuss with them. They came to see you to say, when I die, this person must receive that. That's the only thought process. But there's a lot of things around this that we also need to discuss with them. I mean, the next discussion I would probably have with the client is what we call the security clause. Security. Now, again, there's this thing in law that if you want to be the executor of a deceased estate, there's a good chance the master's office is going to compel you to put down security. Now, for those who do not know what security is, it's like a sum of money or a bank guarantee that you give the master's office that says, if you are negligent and cause damage to this deceased estate, so in other words, if because of your conduct, the deceased estate loses money, then the deceased estate may claim that money from you. So you as executor will have to pay in to cover for your negligence and the damages, which is obviously not a great concept. We don't like it, but it is what it is. That's why I like the professional fee clause. It gives you a bit of a safety net. And if you are unable to give the master's office a bank guarantee that says you have X amount available and you are able to pay for any damages should you cause those damages, then the master's office is not going to allow you to be executor of the deceased estate. So you are going to lose all that money. So I speak to my client about this, and I ask my client, do they feel it's necessary for me to give security if they pass away? If the client says, look, I don't think it's necessary, I'm excusing you from having to do something like that, I put down a clause in the will, I call it the security clause, and I say the executor need not furnish security. So I'm trying to say that whoever's the executor, they don't have to put down large sums of money before they're allowed to be executor of the deceased estate. Now, I can, however, tell you, from a practical perspective, the master's office, even if you have that in your will, the master's office may still compel you to give security. The chances are less likely. However, they may still compel you to give security. That's just something I've picked up because the master's office decision overrides the testator's decision when it comes to security. Just thought I'd mention that so you keep that in the back of your mind going forward. But if you do intend on dealing with a lot of deceased estates and winding up deceased estates, and you don't think you're in the financial position to be able to give bank guarantees that you have large amounts of money in the bank that you are able to pay for any damages you may cause, what you could do is you could speak to different legal insurers, and you can actually take out insurance that covers you for bank guarantees should you need. So you might be paying, let's say, I don't know, 600 Rand a month or 1,000 Rand a month for this insurance. But then when you are the executor of a deceased estate and the master's office compels you to give security, then that insurance will give the security for you on your behalf. So that covers you in case you're in a position where you don't have X amount of money available. And I mention that not because you need to study that, but it's just something to keep in the back of your mind going forward if you do find yourself dealing with a whole bunch of deceased estates. So again, another clause that your client probably did not come to discuss with you, but what you need to discuss with your client. Outside of that, I might have a collation clause in my will. If my client doesn't agree with collation, I'm going to have to exclude it. I'm going to have to mention it in my will and say that it is excluded, because remember, it's common law, so it applies automatically. So if your client doesn't like collation, I would have to have a heading of collation in my will that says it won't apply. Section 2B, Section 2C of the Wills Act. We spoke about this already at the beginning of the lecture. You've got to speak to your client about it. If your client doesn't like it, we're probably going to have to put that as a heading in the will as well and address that issue. Indicate that it will not apply and indicate, what is to happen if there's a divorce. What is to happen if someone is predeceased? What is to happen if someone renounces their inheritance? Remember, if your client doesn't like common law, you have to change it in your will. Otherwise, common law will apply. Outside of that, ladies and gents, you can also, obviously get to the aspect of the will that your client is most interested in, and that is who is to receive what, eh? So who are the beneficiaries of the deceased estate? Now, ladies and gents, always divide your beneficiaries into two different classes. You get two different types of beneficiaries. You get legatees and you get heirs. I'll say it again. You get legatees and you get heirs. Legatees, or a legacy, are beneficiaries to a will who receive something specifically. Legatees are people who receive something specifically. Let me give you an example. If I leave my house to John, that would make John a legatee because John's getting specifically my house. If I leave my car to John, that would make John a legatee because John is getting my car. If I leave 100,000 Rand for John, that would make John a legatee because John is receiving 100,000 Rand specifically. Legatees are people who receive a specific something. Heirs, on the other hand, they are beneficiaries that share in the residue of my deceased estate. The residue is what is left of my deceased estate. So let's say I'm married, I say my wife and my 2 kids, they are the heirs of my deceased estate. That means whatever is in my estate must be divided equally between the 3 of them. Okay, remember the 250 rule only applies for intestate law, hey? So don't let that even cross your mind. I'm mentioning it because I know some of you that might have crossed your mind. Remember, that's intestate law. We're dealing with testate law at the moment. Nothing to do with last night's lecture. When you have testate law and you have a will, you appoint your beneficiaries. They call them heirs. They share in whatever you leave for them. Okay, so I might have said John must get my car, and I make my wife and my child the heirs of my deceased estate. That means I have a legatee and a heirs. John is my legatee, and my wife and my child is my heirs. They get in what's left outside of the car. Someone can be a legatee and an heir as well, ladies and gents. I can leave my house for my wife, I can leave my car for my child, and I can say my wife and my kid are the heirs as well. So ladies and gents, let's just stay muted. I'm getting some noise in the background. So it can happen that in that scenario, what are you saying? You're saying when you die, your wife is a legatee because she must receive the house. Your kid is a legatee because they must receive that car. But I'm also making my wife and my kid the heirs, meaning whatever's left, let them share it 50-50. Heirs share in what is left. So remember, when you appoint beneficiaries, you get legatees and you get heirs. Right. Other things that, is quite relevant, ladies and gents, that often play a part. You will see guardianship, who is to look after kids if you pass away. By law, naturally, if the mother passes away, then the father looks after the kids. Or if the father passes away, the mother looks after the kids. But it may happen that one of the parents are predeceased or don't have a relationship with the kid, or are legally not capable of looking after a child. Then obviously, who is going to be the guardians of your kids when you pass away becomes very, very relevant. So you might want to address that aspect in a particular will as well. Interestingly, you also see funeral direction, come into a will. In other words, what should happen when you die? Should you be buried? Should you be cremated? Some people like to give their bodily or donate their bodily organs for research when they pass away. I mean, that's something you would need to address in your will. So that might come in, ladies and gents. Just interesting, if you do have the intention, just to stop, I think it's Claudia or HKAMOGELO. You are unmuted. If you can just mute yourself there. I'm getting quite a lot of background noise from you. Thank you so much. I see you've muted yourself. Great. All right. So just back to what I was saying about bodily organs. The rules indicate that if you wish to donate your bodily organs for research or for whatever purpose, you have to specifically indicate who is to receive it. So by making a statement in your will to say, I donate my bodily organs for research when I die, that means absolutely nothing. It's an invalid clause. You must indicate what institution is to receive your bodily organs. So if any of you have the intention on doing something like that, or you come across a client that has the intention on doing something like that, make sure you indicate in the will what institution must receive this donation, in other words. Then there's another aspect of a will or of testate law that I really think we need to have a chat about. And it's what we call the testamentary trust aspect. That's quite a big one. But I think we're due for a little break, ladies and gents. We've been going for 1:20, and it's been quite a lot of info the whole time, but I haven't stopped speaking. So on my cell phone, I see it as 18:51. So let's take a 9-minute break. At 7 o'clock, we return and carry on. I'll also open the floor up for questions after the break for a period of time. So yeah, let's take a 9-minute break and then we carry on. Catch you all now. Right, ladies and gents, it's 7 o'clock. I think let me finish up with testate law and then I'll open the floor for questions. I think that's probably a better way to do it. Still a couple things I just want to discuss with you that you should know about testate law. And there's another clause in a will that you might want to consider and you do need to know about and understand. And I said that's called the testamentary trust clause. Now, let me put this in perspective, ladies and gents. As a beneficiary to a will, you can only inherit if you are 18 years or older as a major. Okay. So what happens if you have kids and they are beneficiaries to your will? Then let's say your kids are 10 years of age, for argument's sake. And you've left them a house and you've left them cash or whatever the case may be to help them when they are older. The problem you have is they're not going to receive that inheritance until they're 18. What's going to happen is someone else, and you're not sure of who, is going to have to open a trust and they're going to have to keep that inheritance for them, for your kids, until they reach the age of 18. And then they'll receive their beneficiary or their benefits. And that'll be run by someone outside of your control. Yeah. Now, ladies and gentlemen, just make sure we're muted. I'm getting from Nolita. Nolita, you are not muted. You can just mute over there. Thank you so much. Right. Now, you can create a testamentary trust where you pretty much decide how things are supposed to run for your kids until they turn the age of 18. Now, the concept of a trust is you need to appoint 3 trustees. A trustee is someone who's going to run that trust for you and manage your kids' inheritance until they, reach whatever age they're supposed to before they inherit. So you can appoint family members, you can appoint friends, you can appoint a professional person, basically anyone that you trust to look after your kids' deceased estate until they are able to take the inheritance. And I think that's the concept behind it, appointing people you trust that can look after this deceased estate or your kids' inheritance until they turn 18. Otherwise, other people are going to be appointed that is outside of your control. And this is also the concept why I said your will change. I mean, if you have a will and you have kids that are under 18, best you have a testamentary trust clause that says what is to happen to their inheritance until they are majors. But if your kids are above 18, there's probably no point of having a testamentary trust clause anymore because they are majors now and they can receive the inheritance. So your will would possibly change once they're above the age of 18. Now, what does common law says? Common law says that your kids will take the inheritance when they are 18. Now, to be fair, most people believe that is not a good idea because the kids will receive the money. They are too young to understand how to deal with the money. They'll tend to neglect to go and study after school or advance their careers or get an education, and they'll tend to go and squander that money as well. That's the idea behind it. But by law, they're going to receive it when they're 18. But if you created a testamentary trust, you can indicate what age your kids should be before they're allowed to take the inheritance. That's any age you decide upon. What I've seen in practice, the age that most people believe, to be a good age for someone to receive inheritance was 25. 25 seems to be the age that people think is a good age. I mean, and the idea behind it is that it gives them time to obviously understand life, to work, earn their own income, to value money, and to also go and study and get an education behind them. But that's completely in your hands. If you're happy with 18, you don't even have to say anything because automatically when they're 18, they'll get their inheritance. You might prefer 21, 23, 25, 27, 30. It's completely up to you. And that's the whole concept. You are making the decision, not someone else. And then for me, the big part of creating a testamentary trust is creating rules by which these trustees need to work within. Because I look at it and I think, well, if you leave your child R1 million and your child is inheriting 15 years from now, is that R1 million the same as R1 million today? Obviously not, ladies and gents. It's not worth that much. But you can make that money work for you by creating certain rules of how the trustees need to manage that money for your kid. I mean, you could indicate that that money needs to be investment. It needs to be invested. You could indicate whether you want a low risk, medium risk, or high risk investment. You can indicate what type of interest returns the trustee should be looking at, because you want to grow that money over time so it runs with inflation. So even though it might be 3 million in 15 years from now, it's worth what R1 million would have been worth today because of the inflation rate. I mean, you might leave an immovable property for your child. Now, I look at that scenario and I think, well, why don't we in the trust speak about this immovable property and let's make it work for my kid? Let's say that maybe we can lease it out for 10K a month. So let's say that the trustees are directed to put tenants into this immovable property, and you indicate how that rental income must be managed. Now, there's so many options you have, ladies and gents. I mean, let's just touch on the face of it. I could turn around and say, right, if we're receiving 10K rental income, 5,000 Rand of that must be used for maintenance for my child on a monthly basis, for argument's sake. So now I'm letting this money govern my child's upbringing as well. Use half of it as maintenance and let that run with inflation. The beauty about property is that rental income automatically runs with inflation. But there's now 5K rental left. And I might say, take that 5K and put it with the other R1 million I had and reinvest that money. So basically, over the course of 15 years, that property is paying my kids' school education, varsity education, and the additional rental income is being reinvested. So there's more and more money. I might even turn around and say the other R1 million, purchase another property with it as well. So when my kid's 25, they have 2 properties, plus all the rental income that's been coming from that property has been used for their upbringing, and it's also been reinvested. So they have 2 properties plus money waiting for them when they're the age of 25. But no one's going to do this for you. But if you create a testimony trust, you can do this. Now, it's more than that. Think of your rental property. That property is probably going to need some upkeep. Hey? So you need to indicate what the trustee should do. They need to make sure the lawn is cut. There's garden services. If there's damages, they must use part of the rental income to fix those damages. What about the type of tenants you're going to have? Should the trustees do credit checks on these tenants? Should we rather let an estate agency manage the rentals of this property? Or would I prefer if we rent it out privately? You know, what do you want? I mean, choose your poison, in other words. And that's what the testimony trust does. It gives you the opportunity to maintain your kids, to make sure your assets grow with inflation, and to maximize your kids' inheritance. Because I look at R1 million and I go, right, if my child's going to inherit 15 years from now, I need that to be a lot more than R1 million. How can we set this trust up to make that money work for my kid as they're growing older, and to make sure they have a bigger inheritance by the time they hit 25, for argument's sake? And that's the whole concept of a testamentary trust. I strongly advise that you create one for your clients or for yourself. If you have kids that are minors, and consider who you want to be your trustees, consider what age you want your kids to be before they inherit, and consider whatever you're leaving for your kids, how that needs to be managed and how that needs to be run. You know, and if you start thinking about it, there's a million things you actually have to say about it. I mean, I remember a will I did a couple of years back. The will was 12 pages long. From those 12 pages, 10 of those pages dealt with the testamentary trust clause. The other 2 was everything else. So what I would advise is you can Google it. I don't know what notes you guys have with you, but you can literally Google an example of a testamentary trust. I would suggest you just read it. It's going to be a basic example, but just read what that person who put that example on the internet is saying in their testamentary trust. Just to give you an example of people's thought processes, what we need to consider, etc., etc. But a testamentary trust is a huge and important aspect of any will the moment that you have kids that are under 18. Because again, if you don't speak about it over there, the problem is that someone else is going to have to make those decisions for you. And you don't know if they're going to be acting entirely in your kid's best interest. That's the idea behind that. So there's a lot of things in a will. Like we understand that a will, if we comply with the formality, is going to be valid. And we can say what we want. But the point I'm trying to drill across is understand common law. All these different examples of clauses in a will I've been sharing with you, understand what they mean, so you are able to give the best advice to your client and create a will in such a fashion that it covers everything. There's nothing that's left up for dispute. If there's any issue that pops up, the will indicates how it's supposed to be dealt with. And ultimately, keep in mind, if you are the executor of that deceased estate, you don't want to wind up that deceased estate and have problems. You know, you've heard of these people that 10 years later, they're still struggling to close down the deceased estate. Now, all of a sudden, that 180K you were going to make, is it worth it if 10 years later you're still struggling to do it? Or still struggling to wind up the deceased estate? Probably not, ladies and gents. So you don't want issues. The beneficiaries don't want issues. It's in no one's best interest the longer it takes to wind up a deceased estate. So make sure that that will is set up, leaving no stone unturned. And that is something that doesn't just apply to a will. It applies to any contract. I mean, I want to sell you my cell phone. We agree, you're going to give me 5,000 Rand and I'm going to give you the cell phone. Now, if we made a contract, we can probably do one paragraph that says Carl is selling the cell phone to John. This is the type of cell phone it is. John is going to give Carl 5,000 Rand on this date, whereby Carl will give John the cell phone. We have a contract. We sign it. But why do you see attorneys don't have a one-page contract for that? That contract is probably 5 pages. It's because we think of everything that could go wrong when I sold you the cell phone. If you don't pay me properly, if the cell phone is defective, if me and you reach an agreement and you breach the agreement on the cell phone, if the day before you're supposed to take my cell phone, you change your mind, what's going to happen then? So we cover all the different things to make sure that if we dispute something, we don't have to go to court because the contract says what is to happen. It explains if we fight about this, this is the result. Everything is clear. And that's what we try to do in a will. That is why we have different subheadings, different subclauses in a will, to try and make things clear so there's no confusion, that it's easy to read. And that's the difference between a good will and a bad will. Not a correct will and a wrong will, a good one and a bad one. Now, further than that, ladies and gents, you might also come across joint wills. I mean, a joint will, very simple. If somehow that pops up in an exam for a 2-mark question, what is a joint will? If you come across something like that, ladies and gents, very, very simple. A joint will is when 2 or more persons create a will in one document. I'll say it again. A joint will is when 2 or more persons create a will in one document. You often see this with married couples, ladies and gents. So they will create a will together. Let's call the married couple John and Sue, for argument's sake. And the will say, if John dies, then Sue must get this and the kids must get that. And then it will say, if Sue dies, then John must get this and the kids must get that. If John and Sue die at the same time, then the kids must receive this. If John and Sue and the kids all die at the same times, then Tabu must receive that and Pete must receive that, whatever the case may be, right? So you have 2 or more persons combining their will into one document. So John doesn't have his own will, Sue doesn't have her own will. They've put it together into one. You are allowed to do that, ladies and gentlemen. Very common amongst married couples, or at least that's what I've come across. I've never had someone request a joint will unless they were married to one another, and they're running their estate sort of together. Then it makes sense because what's mine is yours, and etc. etc. So you can do that. That is indeed an option. And there's one other thing that we need to speak about with testate law. And you need to know this, ladies and gentlemen. It's what we call massing. Massing as in MASSING. Now, I'll be very surprised if you come across massing in your career. It is an outdated concept. It is something that used to be used quite a lot decades ago. I don't think I don't see the point of ever doing massing, and that's why you don't ever come across it. But for exam purposes, I've often seen that they like to test to see if students know what massing is exactly. So you must be able to talk about it. I don't think you'll ever do it, but for exam purposes, you must be able to talk about it. So let's just discuss massing there for a moment. Massing is also when two or more persons create a will in one document, but there's a difference. When two or more persons create a will in one document, we call it a joint will. When two or more persons mass their estates together, we call it estate massing. And there's a big difference between the two. And when I'm done explaining it, you will see why people just do joint wills and they do not do massing, because massing is a bit complicated. So let me explain it, take your notes, and obviously if you don't understand it, you will get the opportunity to ask a question, as I will open the floor for questions thereafter. So massing, and I'm going to say things and then I'm going to explain it afterwards. Okay. So massing kicks in upon the death of the first dying. I'm going to say it again. Massing kicks in upon the death of the first dying. So let's say husband and wife, for argument's sake, mass their estates. They choose to do estate massing. What happens then is they've joined their estates into one. Okay, so it's no longer two separate estates, it's one estate. All right. And let's say their beneficiary is their child, for argument's sake. Okay. If husband dies, massing says that both have died. If wife dies, massing says husband has also died, because it kicks in upon the death of the first dying. So let's say I am married and my spouse and I own a house, a car, furniture, and we have $1 million. Now tomorrow my spouse passes away. In the eyes of the law, I have also passed away. So our house, our car, our furniture, our R1 million that we have saved, all goes to our beneficiary. In my example, it was our kid. So our kid becomes the owner of our entire deceased estate. That is what estate massing is. Now that's a tough concept to comprehend, and it doesn't sound very clever, but it is part of our law. So you see, if we had a joint will, I would have said, if I die, this is what happens. If you die, this is what happens, and we will cover each other. But if you have a master estate, if one of us die, in the eyes of the law, both of us has pretty much died, because our entire master estate is now going to be transferred to our beneficiary that we elected in our will. In my example, it's the kid. Now, this could be problematic. The law goes a step further, and the law obviously recognizes that this could be a problem. I mean, if we both die of old age, it's probably not an issue. But what happens if I'm 45 and now I lose my house, my car, my furniture, and all my money? It goes to my child. It could obviously be devastating upon me. So massing says the survivor of the two, let's say my spouse passed away and it's still me. So I, as the survivor between me and my spouse, must receive some or other limited benefit. I'll say it again. The survivor of the two must receive a limited benefit. Now remember, ownership is going to pass to my kid in the example that I gave. By law, it passes to the beneficiary. I'm just using my child as an example. If ownership passes to my child, what limited benefit could I get? So if we had a house and my child is now going to become the owner of that house because my spouse passed away and massing is now kicked in, so everything goes to my kid, what limited benefit could I receive? Well, let me give you an example. For example, I could get a habitation over the house. So yes, the beneficiary becomes the owner of the house, I lose ownership, but I receive the right to live in the house. So at least I have a roof over my head. That's what a habitatio is. Or the beneficiary becomes the owner of the house and I receive a usufruct over the property, for argument's sake. So you see, when I say some other benefit, it means they don't want me to be destitute and on the streets because my spouse has passed away and we have amassed estate. By law, ownership passes over to the elected beneficiaries. But we've got to protect the survivor to some or other degree. And we have to give them some or other benefit. Make sure they can still use the assets even though ownership has passed on to the kids, for argument's sake. Then there's one more element to massing as well I want to mention. Again, the law recognizes how hard this could be on the survivor. And I think it goes without saying. So this is the only type of, let's call it, aspect of testate law that can actually be cancelled after someone passes away. What I mean by it is, massing says, upon death of first dying, massing kicks in. But the law goes further to say, the survivor of the massed estate, in my example it was me, I can now elect whether I want massing to continue or whether I repudiate it, I cancel it. I say, look, I can't do this massing anymore. It's going to kill me financially. I won't be able to do it. It's not a good idea anymore, in other words. If I choose to accept the massing, we use the term 88, then obviously it will continue. Ownership will be passed over to our elected beneficiary, and I'll receive some or other limited right, like we spoke about. But if I elect to repudiate the massing, in other words, I say this is not going to work anymore, I have the option to do so. However, there is a consequence. If I repudiate the massing, obviously myself and my spouse who has now passed away, in my example, our estates will be split. My spouse will have her estate, which will be the deceased estate, and I'll have my cut from the estate. That's fine, because I've elected to cancel massing, so our estates are now split. So I keep my estate. However, the consequence is I may not inherit anything from my spouse's deceased estate. So you forfeit the right to inherit anything from your spouse's deceased estate should you elect to repudiate massing. That's the punishment you take for electing to repudiate it. So in other words, your spouse's share of the estate, you can have no claim to it because you've repudiated massing, and that's your consequence for it. Now, from listening to all of this, ladies and gents, you can see why I'm telling you that massing doesn't really have a home in our law anymore. It's been replaced by a joint will. A joint will is such a better concept. We don't have to worry about any of this. Yeah, if we want to combine our will into one document, no problem. But our will indicate what will happen if each of us die. We'll protect one another. If we both die together, we'll give everything to the kids for argument's sake. But obviously, if you're still alive, you must receive an inheritance. The kids can take this, you can take that, blah, blah, blah. No issues. A simple concept. But before a joint will was created, there was estate massing. That used to be put, and that has not been removed from our law. You don't see it in practice anymore, but estate massing still forms part of our law. So it is an option. So you've got to understand it. So just to recap estate massing to make sure we didn't miss anything. What you have to know from estate massing. This is similar to a joint will. The only difference is it's not two or more persons creating a will in one document. It is two or more persons massing their estates into one, okay, forming one estate. And the idea behind it is if one of those people die, then the law sees it as if both of them have died. And everything they own together that was massed together will pass over to the elected beneficiary or elected beneficiaries. However, the survivor must receive some or other limited benefit. They lose ownership, but they must still be protected. And I gave you the example of maybe a habitatio or a usufruct or something along those lines. And the other concept I said is the law recognizes still how tough this can be on the survivor, and it gives the survivor the opportunity to repudiate and cancel the massing, but there is a consequence. If you do so, you lose your right to inherit from the deceased person's deceased estate. This is what you need to know for massing. I stress again, I don't think you need to know it in practice, and I think after the exam you can pretty much forget about it probably. However, for exam purposes, that question may come up and you might need to be able to put that down to whatever question comes up and write it down on a piece of paper. That's why I bring it up, for exam purposes specifically. Now, ladies and gents, what we've been discussing this evening is very different to what we discussed last night. I mean, last night we spoke about intestate law, when you die without a valid will, and there was rules we had to know. We have to study those rules. If you get an exam question and they speak about intestate law, you go back to Monday night's lecture and you go, what was the 5 rules we looked at? And you apply them strictly, because that's what's going to happen in practice. If you are appointed as executor of a deceased estate and that person did not have a will, so the master's office appointed you because they needed an executor, or the family members came to you and said, please help us wind up this deceased estate. They died without a will, but we don't know what to do. You need to know who needs to benefit. So you apply your rules that we looked at last night. But if someone passes away with a valid will, and we've looked at what a valid will is, we need to follow the will, because the will tell us who gets what. So we forget about last night's rules because there is a will that tells us who gets what. We understand that as long as you comply with the formalities, you can say what you want in your will. But I've explained to you aspects of common law. I've given you subheadings to consider in your will, and I've said if you understand it, you can deal with it, because there's no specific way about how you need to write it in a will. You just need to bring your points across in the will. And if you understand the different headings to consider, you can draft a will, ultimately. If you understand common law, you can draft a better will than the average person as well. All these aspects, and if you look at it, you can be tested in an exam on these. I mean, I could ask you, what are the formalities for a valid will? I could ask you to explain collation. I could ask you about section 2B, about 2C. I could ask you to draft a certain clause in a will. And you can draft any clause in the will as long as you understand what that clause means. Hence I said, just know what the clause means. If you understand that, you can draft a very good will. All right? Keep in mind, massing is a weird concept, but it's something you need to know. You need to study it for exam time. There's a lot of things I mentioned tonight that aren't really relevant for an exam, but it's relevant for being a good lawyer. Like I told you about understanding the real consequences of a usufruct, understanding what challenges there is when dealing with immovable property in a deceased estate, understanding what's the real consequences of collation. That's things that you won't be tested on per se, because it's from a practical perspective, not a theoretical perspective. If you look at it from a theoretical perspective, testate law, there's not that much that you need to know, But from a practical perspective, there's so much to talk about at the end of the day. Right? That's in a nutshell testate law, ladies and gents. So we've looked at testate law and we've looked at intestate law. The only difference is the one is with a valid will and the one is without a valid will. If it's with a valid will, follow the will. If it's without a valid will, last night's lecture, apply your 5 rules in determining who gets what. All right. Ladies and gents, I'm going to open the floor up for questions now, so please raise your hand. Dion, I see your hand.
Thank you, Kyle. I think you should get a glass of water after a lengthy speech. But I'm in load shedding, so I just want to get my bearings right here. It's about last night's lecture. You can hear me?
I've got you, Dion. I was actually sipping on some water as you were speaking.
Thank you. I want to take you back to last night's lecture and about the Roman Dutch maxim, die bloedige hand neem geen erf. On page 16 of our guide. And they say that where a beneficiary is disqualified, no rights vest in the beneficiary, and the bequest is accordingly not transmitted to the beneficiary's heirs. That correct?
100% correct, yes.
But if I go to page 298 of my guide, there's an example. Eskom performed wonderfully in my town. Page 298, there's an example of interstate succession, question and answer. And child one murdered the deceased, which is the father, or A. But in the answer, they gave child one's children 150,000 each. So if I've read that on page 16 correctly, that die bloedige hand erf niks, then it means that the beneficiary or the heirs of that beneficiary doesn't inherit. But on the example, they gave as if that die bloedige hand really inherit something from, or the beneficiaries, the heirs of the beneficiary inherited. I don't know whether you follow me on that one.
I got you. It's a good question, Dion. I'm actually glad you brought that up. This is something, when I started out, I struggled to wrap my head around that concept. And the reason why I struggled to wrap my head around the concept was because the answer there to doesn't make sense to me. But I've done some digging into it, and I've come to why the law runs it a certain way. So let me be comprehensive about my answer here. So when Dion is speaking about disqualification, I mean, we've been speaking about people that are predeceased and the children stepped into their shoes. And we've been speaking about people that repudiate and say, I don't want the inheritance. And we said that goes to the deceased person's surviving spouse then. But what about people who are disqualified from inheriting? Now, ladies and gents, what's the main basic example for being disqualified from inheriting? If I go and murder you, I may not inherit from you. Obviously, I would be disqualified. So what is the rules that follow people that are disqualified from inheriting? Now, the rule is very simple. If you are disqualified for inheriting, you can obviously not inherit. However, your children may step into your shoes and inherit through you. So the rule says treat people that are predeceased the same way you treat people who are disqualified. If you are predeceased or you are disqualified from inheriting, your kids may step into your shoes and inherit. Now, that concept sounds strange because my hands is dirty, so the inheritance shouldn't be coming my way. And it's not coming my way, but it is because my kids are stepping into my shoes and inheriting. Now, that concept I struggle to understand because it doesn't make sense. However, the reasoning behind it is that because I went and, let's say, murdered this person, now I'm disqualified from inheriting. My kids cannot take the blame for my actions. So it doesn't disqualify my kids, it only disqualifies me. Hence, my children are allowed to step into my shoes and inherit through me even if I am disqualified from inheriting. Now, ladies and gents, if I go and murder someone, I'm going to be spending, well, that 15 to 25 years in prison, depending on what degree of murder we're speaking about here. And my kids will receive the inheritance. So I make no gain from that. I make no gain sitting in jail for that period of time. So I suffer my consequence, which is I get nothing. My kids, on the other hand, cannot take the blame for my conduct. Hence, they are allowed to step into my shoes and be treated the same as predeceased. And that's the idea behind it, Dion.
Oh, thank you, man. Clearly.
Cool.
Thank you.
100%. Okay. Forgive me if I'm saying this. Is it Nathan Naidu?
Yes, sir. There's two questions. One from yesterday regarding the, I think it was Rule 4, where the brothers benefit when there's no kids. Now, if one of the brothers or sisters are deceased, do their children automatically benefit from their share? And the second question today relates to collation. If the vehicle is on hire purchase, what happens? Thank you.
Okay. So regarding your first question, if one of the brothers were predeceased, yes, then the rule applies where if they have kids, those kids can step into their shoes. So it doesn't matter what rule we're on, if we're on rule 1, 2, 3, 4, or 5. Okay, well, obviously not 5 because that's when it goes to the state. If you are predeceased and you would have inherited if you were alive and you have kids, your kids can always step into your shoes and take your inheritance. Regarding the second aspect of the question, just to make sure I understand it correct, are we referring to, let's say, a vehicle that, let's say, could I say a vehicle that's still being paid off as well? Would that cover your question? I mean, if we speak about a 200K vehicle that I purchased for you, chances are I've got it under finance and I've still got to pay off, maybe still even paying off the interest on that vehicle, or you are not the owner of that particular vehicle. Are you referring to that concept, Nathan?
That's correct, sir.
Yes. So when we speak of assets, we look at the true asset value. So the question is, the deceased estate will have to now go and pay that vehicle. So that 200K for the vehicle, remember, if it's under finance, the bank will have a claim to it. So the deceased estate would have to pay off that vehicle. And if it was my kids, my child's, if I bought it for them, they would become the owner of the vehicle and they won't carry the burden of that payment ultimately. So it wouldn't affect the situation because the 18-year-old will still get the vehicle and they'll get the vehicle free of any financial obligations because the deceased estate will have to pay for it. So the 18-year-old will still sit with a 200,000 Rand vehicle ultimately.
Okay, thank you.
Cool. Right. I'm just going down the list, ladies and gents. All the hands have popped up, so I'm just going down as I see it. Okay, the next one I see is Aisha.
Sorry, evening, sir. Okay, I have one question. Just does collation apply to intestate as well?
Correct. Collation, a common law concept that applies in any aspect of the law, yes.
So whether you have a will or not, it will apply?
Yes.
Okay, sure.
So
Thanks.
let me put it this way. Section 2B, that applies for testate law. Okay. The only things that I spoke about that cover both testate and intestate law was section 2C, when we speak about predeceased, disqualified, or people who repudiate. That covers both testate and intestate law. Obviously, adoption covers both testate and intestate law, although it's irrelevant in testate law because the will tells you who gets what. Unless the will says all my kids will inherit, then remember, if you have an adopted kid, they will still be regarded as your kid. And then collation is also testate and intestate law. You good, Aisha?
Yes, I am. Thank you so much.
Perfect. Next one on my list, Piwe.
Good evening.
Evening.
Yes, I've got two questions for today's lecture, the tested one. The first question is the issue when one is married in community of property while he has a valid will. Isn't it that the will only apply to the 50% of the party, not like on the whole estate of those persons? Then the second one, it's on the witnesses for the will. The witnesses should know the content of the will that they're signing for, or they just sign as spectators there. Thank you.
Right, Sipiwe, first part of your question, 100% correct. Remember, marriage supersedes testate and intestate law. So you can say what you want in your will. If you are married in community of property, automatically half of everything is your spouse's. So when you speak about leaving inheritance for beneficiaries, you're only speaking about your half, not the entire estate. So you're correct over there. With regard to the witnesses, and this doesn't just apply for wills, this applies for any contracts. Let's be honest. Witnesses have no idea what's going on in a will. That's or any contract. That's just people who, to complete the formalities of the contract come and sign. So it's not required that a witness understands a particular will. However, the purpose of the witness signing the will is that they can, in their presence, see the testator or testatrix also sign the will. And the whole concept of the witnesses is to try and avoid any fraud, because those witnesses will be brought to court to prove that they saw the testator sign the will if there is a dispute. So the point of the witnesses is not to understand the will, but rather to confirm if there's an issue that they saw the testator sign the will and that it is not a fraudulent document. You good, Sipiwe?
Yes, thank you, sir. I'm clear. Thank you.
Perfect. Just before I go on, there's maybe another concept that I can tell you about. I think it was Dion at the beginning brought up disqualification, and I said to you that a main example of disqualification is obviously if you murder someone, but it is also part of our law that if you are a beneficiary to a will, you may not be a witness to that will as well, right? And this is all to try and avoid fraud. The rule actually states you can be disqualified from inheriting if you were a witness to a will or if you drafted someone's will for them. Because the whole point of these witnesses is to confirm the testator's signature, as we've just established with Sipiwe now. However, the courts are very sort of cautious of people unduly influencing other people, right? That's the thing. So they're saying you can be disqualified as a beneficiary to a will, not only if you just murder someone, but also if you are a witness to the will or if you drafted the will for them. So I mentioned that, just always make sure, ladies and gents, whoever is witnessing the will, make sure they are not a beneficiary to that particular will as well. Okay, I thought I would just mention that because it is something I didn't mention a bit earlier. Right, next hand I see is Caiphas.
All right, thank you very much, Mr. Kyle. Two things from yesterday. One relates to the issue. I think one colleague asked about a situation where a person marries more than one spouse. And then, if I remember, your response was in terms of the first marriage, it would be the estate will be dissolved in terms of in community of property. And I think I'm also looking at I think it's section 676 of the Recognition of Customary Marriages Act, which says if somebody marries a second person, the first marriage gets dissolved, and then the court needs to put together a new regime in terms of the new marriage. So I think we also need to be cautious in that respect, and more so because we also have section, I think, Recognition of Customary Marriages Amendment Act 1 of 2021, which deals with how we deal with the matrimonial property regime for people who are married in more than one marriage. So I think that is one area I want to bring to your attention. And then the second issue, I'm just inquiring in the light of the constitutional principle of the best interest of the child. Now, I'm going to give this scenario and maybe then pose my question. If, let's say, for instance, we have a situation where this person, it's a husband this time around. He was married to this particular spouse and the first spouse dies, and then maybe they have children with the first spouse. And then later he marries another spouse customarily. And then maybe sometime down the line, then the husband dies. And assuming this husband had about 400,000 in the estate, if we then follow Rule 1, it will say that 400,000 will go to the wife, who might not necessarily have the best interest of this guy who passed away, and so forth and so forth. So I'm just wondering that if the emphasis is too much on, giving the estate to the wife, well, how do we deal with the best interest of the child in section 28, subsection 2 of the Constitution? Yeah, so those are the two questions that, or two issues I'd like to bring. Thank you very much, Mr. Carr.
Cool. Kavus, just quickly.
Don't ever come to my room.
On the second child you're speaking about, on the second example you're speaking about, how old are those kids? Are they under 18 or over 18?
Yeah, let's take an example where they are under 18. And we know
I've told you guys not to talk.
Yeah, and maybe given the context that, the fact that this person is a second wife might not necessarily have the best interest of the kids.
So I must hear you again here.
Ladies and gents, just make sure that we are muted. I'm getting someone in the background. I don't know. I think it could be.
I think it's Mabatu. Yeah.
Mabatu, yes. Just check there. You are not muted. There we go. Thank you.
Yeah. So I'm just giving that scenario that.
Yeah. Okay. Good.
Yeah. So this guy has passed away. Yeah. Yeah. No. Thank you very much.
Okay. Perfect. So it is automatically done. You'll actually see it later in the week. So that's why I asked why if the kids are under 18. Look, if those kids were above 18, sorry, they're going to get nothing. It's just the law. We can't bend it. But if the kids are under 18, remember, any kid that's a minor that still relies on their parents are entitled to a maintenance claim. All right? So those under 18 kids will launch a maintenance claim against the deceased estate. And a maintenance claim is regarded as a creditor. Now, it'll make sense later in the week, but creditors are ranked above everything else. The ranking goes creditors, marriage, legatees, heirs. You will see later in the week. So before we even divide this money amongst everyone, we have to pay everyone off. I mean, I can't give someone a house if I still owe the bank a million rand on the house. It's not my house, And the same contents with maintenance. I might have 3 kids that are 10 years of age, for argument's sake. Those kids need to be supported. Now, if I have 400K Do you think if those 3 kids lodge a maintenance claim against my estate until they reach 18, that 400k is not even going to be enough? So all my creditors would have exhausted that money. Ultimately, in real life, my wife, that spouse of mine, would get nothing because the maintenance claim would have exceeded that 400k already. So all kids under 18 are protected through maintenance claims, and maintenance claims rank above marriage, legatees, and heirs. What you often find in practice is a person has a will that says, my spouse must get this kid must get that, this friend of mine must get that. No one's going to get anything if there's no money available. I might think I'm leaving them stuff, but remember, my creditors are going to first have a go at my estate. Everyone I owe money to must be paid. And if I have kids there that have maintenance claims against me, they are going to fall under creditors. Chances are by the time they're done, there's going to be nothing left to give anyone that I wanted to give things to in my will anyways. So keep that in mind. You will see when we do the L&D later on. And so kids' best interests, if they are under 18, are regarded as a creditor. Therefore, they are ranked above everyone else, so they are protected. If those kids were over 18, then they're no longer protected with a maintenance claim. Then that spouse of yours would have got everything if you died intestate, because you would have followed the marriage principle and the Rule 1 principle of 250k that we spoke about. So, and I think this also touches on your first question. There is an answer, a way how to answer an exam question, and then there's a practical impact. I mean, I think you guys, a lot of you guys that are clerking would have picked it up. You learn things in varsity, but then you start clerking, and it's as if you know nothing, because you learn the theory, but you don't learn how it works in practice. And I think the answers to my questions span right into this. So in theory, for your second question you asked, the spouse would get everything. That's how you'd answer that exam question. But in practice, we'd first have to see if those kids have a maintenance claim, because that would rank above and beyond. The same with your first question. In theory, you can only have one marriage in community of property, and that will be with your first spouse. The second or third spouse cannot be in community of property, therefore they have no marital claim. So you sort your first spouse out in the marriage, your first, second, and third spouse, and all your kids, divide the money between them. If it's less than 250 each, we give each spouse 250 and the kids what's left. So you answer the question the same way we learned yesterday. However, in practice, I mentioned briefly yesterday that there is discretion applied in customary law marriages where the parties have not went and registered the marriage at Home Affairs. And then the judge may intervene and make different orders. So for an exam, answer it the way I said, but in practice, discretion is most definitely applied to customary law, and things may pan out different in the court depending on the magistrate, because they apply that discretion for any form of customary law marriage as well. Does that answer you, Caiphus?
Yeah, I think I'm happy with the first response in regard to children. I think the way you have responded to it, it shows that the best interest of the kids would be taken care of. But I'm not sure if I follow your response in regard to the other question, because I'm looking at it from a perspective of the new Amendment Act of Act 1 of 2021, which deals with proprietary consequences of both monogamous and polygamous marriages. And then in terms of that Act 1, it appears to me that the marriage, or you know, when somebody marries more than one spouse, a new form of property regime is formed, and it talks about equal and joint ownership of things and so forth, and no longer in community of property. And hence I was bringing to your attention that even in terms of the original or principal act, it requires, in terms of 6.7 of the Recognition of Customary Marriages Act, that if you marry a second spouse, you must dissolve the first marriage, which is likely to be in community of property, and the court must then endorse a new matrimonial property regime, in which case it is clarified in terms of Act 1 of 21.
Yeah, I see where I see where we're missing each other, Kaifa. So you must remember that is brought in, all right, and that comes to my discussion where I said you're supposed to register your customary marriages because that creates a different estate plan. But if you do something like that, you must remember you're no longer intestate, and then all of this falls away because you're supposed to have it registered. But unfortunately, what we have in practice is a lot of customary law marriages are not registered. Then that becomes an intestate law question. Then we follow what I explained to you about the 250 rule. That is how you answer that question in an exam, because you can't get that question if the person who's entered into his customary law marriages has registered their marriage. As that act that you just read, that is what it's saying. That is what you're supposed to do. But that's what theory says. But in practice, people don't do this, and we have a problem. So how do you answer it in an exam? You apply your principles, but in reality, in customary law, those principles may be challenged in a court and discretion may be applied in a court. Where in the matrimonial law aspect, that may not be done. The rules are the rules, where the discretion is applied with customary law. So remember that act you read is what's said in law, and it said that if you enter into more than one marriage, you're supposed to re-register your whole estate planning. That's what's supposed to happen. But people don't go and do that. And that's why we have this problem of intestate law as a result. Kaifas, you good?
Okay, yeah, no, it's fine. I'm good.
Cool. Next hand I see is, I think is it Alphas Matabula?
Yes, yes, no, it's Alphas Matabula. Thank you very much. I just want to quickly check on the following questions. Well, you spoke about the issue of any person who drafts or who writes out a will for a testator, not to benefit in terms of the law. But I read as I was reading my notes here with regard to section 4 with capital A subsection 1, where in it says that if a wife or a spouse, in fact, drafts or writes a will, and the court is convinced that there was no fraud in doing so, may benefit from the will of that particular testator. I don't know if I'm correct with this, but the one question is in relation to revocation clause. You indicated that that if there was a will before another will, it was drawn up. You should put a revocation clause. So I don't know if then there was no revocation clause on the first one. Will it apply on the second one to, not to let the first one to coexist with the second one? And my last one is in relation to common law. You say that common law takes place when there is silence. I'm not so sure if it takes place when there is silence in terms of the legislation or in terms of a particular clause in the will. Thank you.
Okay, so I'm going to try to remember those three questions. So the last one, remember there's legislation obviously that's put in place, and we refer to the legislation as common law, as in it takes precedent. But the reason why we call the legislation in the Wills Act common law is because it can be amended. The Wills Act allows you to amend it as long as the will specifically specifies it. However, if you are silent in your will about it, then the legislation, in other words, the common law, takes preference, and that will then be kicked into effect. So, yeah, I think that term common law, that's why we call it common law in a testate law, because you're not forced to comply with it. But if you're silent about it, then it kicks in. The second question was revocation. Okay, so you spoke about maybe, let's say you have two wills. Let's say you create a will today and you put a revocation clause in, and then 10 years later you create another will that puts a revocation clause in. You're like, but does the first will still have, or does it still have an impact? Is it still valid because you put a revocation clause in your first will as well? I think that's what I got from that question. Now, remember,
the first, if I may interrupt, the first will, there's no revocation clause, but the second one, there is one.
Okay, fantastic. So if the second one has a revocation clause, then the first one falls away completely. When we speak of a revocation clause, we look at the last dated will with a revocation clause. That one will take impact. So in that scenario, your first will would completely fall away, and will be your last will that will only be read, because your last will revoked all previous wills before it. Then you also spoke about the scenario of being disqualified because perhaps you were a witness or because you drafted someone else's will. You were 100% correct over there. So what happens is, by law, and again, the law is quite clear. If you sign as a witness or if you draft someone's will, you are disqualified from inheriting. But there's actually case law that advanced that particular rule. And it said that, yes, you are disqualified from inheriting. However, if you can show that this was indeed the true intention of the testator, and that there was no undue influence or no fraud involved, if you can convince the court otherwise, because remember, your point of departure is you are disqualified. But if you can convince the court that this was the intention of the testator and there was no fraud, then the court may allow you to still inherit. But it's quantified. It says it may allow you to still inherit, but not more than what you would have received intestate. So let's say there's a will that says you must receive 2 million rand. Okay. However, you signed as a witness to that will. So now the rule says, okay, you're disqualified. Sorry, you're going to get nothing. So now you take it to court, and you manage to convince that magistrate or that judge rather, because you're in the high court, obviously, that that was the true intention of the testate and there was no undue influence, blah, blah, blah. And the court is actually satisfied that, actually you should still be inheriting. Then the court will say that what happens if this person died without a valid will? Died intestate, in other words. How much would you have received, Carl? Okay. You would have received 1 million rand, not 2 million rand. So I will allow you to inherit, but I'll only allow you to receive 1 million, not more than what you would have received intestate. Right? So if I would have still received 2 million rand intestate, then I can still go and claim my 2 million rand if I can convince the court in that fashion. But if I would have received 1 million rand, I can only get 1 million rand. If I would have received nothing, I'll receive nothing. So they've quantified it to that aspect, and that's in line with what you were reading in your book over there. Did I cover you?
Indeed, you did cover me. Thank you very much, sir.
Perfect. All right. Next hand I see is Taboho.
Hi. My question is regarding massing. You mentioned earlier that the surviving spouse can elect to repudiate. However, there's consequences, and that the consequences is that the surviving spouse might not inherit anything from the spouse. So I just want to find out what does that supposed to mean? If the surviving spouse elected to repudiate, that the estate will be split, when you say that the surviving spouse might not inherit anything from the deceased estate, what is he or she then going to inherit?
Okay, so let's say that I have a master estate with X. Now it means we've combined our estates together and it's worth 2 million. Now I decide to repudiate this massing when X passes away. So our estate gets split. X takes their 1 million and I take my 1 million. Okay, now X has passed away. Let's say X was my spouse. You would agree now that technically my spouse has now died intestate because there's no will governing us anymore. I've repudiated the massing. So now there's R1 million in my spouse's deceased estate. Now, as the surviving spouse, what does intestate law say? It says that money is split between me and the kids, and if the equal share is less than 250k, I must receive 250k. So you see how I would have inherited now from intestate law from my spouse's deceased estate. However, because I repudiated the massing, I forfeit my right to inherit from my spouse's estate. I no longer am able to do so because I repudiate the massing. Where if my spouse had died without a valid will, I would have inherited from my spouse's deceased estate. Does that make sense?
Yes, it does. It does make sense that because of the repudiation, that's why you will only get what's yours, and then what's his, you're not gonna inherit.
100%, 100%, that's it.
Okay, thank you so much.
Perfect. Okay, next hand I see is Mabatu.
All right, thank you. Good evening. So I have about 2 questions. With regards to the joint will, what happens in an event where a party to a joint will decides to make another will that contradicts the joint will? So that's my first question. So let's, for argument's sake, maybe say they included or didn't decide to revoke the previous will. So yeah, whichever way. And then secondly, I would like to, in fact, regarding revocation, why do we have to expressly revoke previous wills? Why can't we just consider the latest will? Because if I go and make a new will, isn't that surely my wish at that point in time? Why do we have to expressly revoke? You know, that's my other question. And then my last question also is around the joint will and the section 2B of the act. So what happens in a situation where there was a joint will and the parties divorce? However, the one spouse dies before amending the will, and they're still within the 3 months window. What happens in that event where there is still a valid joint will of the parties? Thank you.
Okay, perfect. Okay, now just keep in mind that my brain is pretty fried, so sometimes when there's multiple questions, I struggle to remember them. So, for example, question 1 has already slipped my mind. Can you just go back to question 1? Can we do one question at a time? Sorry, it's been a long day.
Okay, no problem. So the first question is around the joint will, that if the one party to the joint will decides to go and make another will,
okay,
and maybe they do revoke or they don't revoke. I mean, what happens in that instance?
Okay, that's a bit of a mess. I actually saw a scenario like that years ago, and it wasn't me that actually was involved, but I was speaking to another attorney about it. So the mess behind that is that it's male fide. I mean, if let's say we are married and we have a joint will, and then I go behind your back and I create another will that benefits, in my favor, after me and you already have a joint will. It's male fide. It's done in bad faith. And in that specific scenario, what actually happened is the surviving spouse, I think it was the husband, he passed away, and then the spouse said, well, here's our joint will, to the lawyer, we've got to execute it. And then it came out that after they did the joint will, this husband went and created a separate will, totally contradicting their joint will. So it was an issue and it went to court. And the court actually determined that when the husband created the second will, he did it male fide. He did it in bad intention and to suit himself. So the court actually declared the second will invalid and ran with the joint will in that specific case. Does that answer you there? That's just from an example I've seen before in practice.
Then what happened to freedom of testation? Because I still have a right. I can change my mind. I'm just thinking around that. What does that not limit your? Yes, you've done a joint will, but you've since changed your mind.
You can most definitely change your mind. But what happened in this particular case is he did it behind his wife's back, and he did it with. If you look at the way he structured the will in that example, he did it to benefit himself, and there was a reason why he didn't tell his spouse. Because he would have benefited more if she didn't know about this will that came up. That's why they determined it to be male fide. But if you if you enter into a joint will, you definitely can determine you no longer want to continue and you want to create a will that replaces the first will. You may do so as long as it is evident that you've done it bona fide. You've decided that it's no longer going to work for you. You have you've made it known to all the parties. Then you may go and do so. But the moment you do something with bad intention to suit your own pocket, in that specific case, the court ruled it was not fair to allow that will to proceed. So yeah, you have freedom of testation, but as long as you are doing something that doesn't if it affects another person, your intention needs to have been made clear to that person that this is what you're doing. Then you can do so. But if it's done male fide, it's a problem.
All right, noted. Thank you. And just on that same matter of joint will, so with regards to Section 2B, if it so happens that we've got a joint will and we divorce and we're still within the 3 months window period. Well, what happens there? So the law would still exclude the ex who is part of the joint will. What happens in that situation?
No, 100%. So exactly as you mentioned over there, the law would exclude it. So if we have a joint will and we're benefiting one another in our joint will, if we get divorced and I die within 3 months, whatever I was going to benefit you is now excluded. If I die after 3 months, it's obviously still included. But they don't declare the whole will invalid. They just declare the clause of where I benefit you to be invalid, because the assumption is now I no longer want to benefit you because we are now divorced and I die within the 3 month period. But whatever I'm leaving for the kids will still be interpreted though. So the fact that it's a joint will does not amend Section 2B of the Act.
Thank you. Oh, and lastly, I just wanted to know why we need to expressly revoke previous will. Why can't we just use the assumption that my latest will is the valid one?
Okay, so you don't need to expressly revoke a will. I mean, if you don't do it, there's nothing wrong with your will. but we do it as a safety mechanism, right? And the reason is because there's been a number of matters that's come down before the High Court where there is more than one will. And the theory that South African law applies is, yes, give more weight to the last will. However, on the face of it, all the wills must be read. And if we can't reach a conclusion on who must receive what, then more emphasis will be given to the last dated will. And the problem you have, before you can get to that conclusion over who must now receive what, you have to run a whole High Court case before the judge will come to this conclusion over what will we're going to interpret and whether or not we're giving the last will the most weight, which usually is the case. And now the fact that you're running this High Court case is costing a hell of a lot of money, and that money is coming straight from the deceased estate, meaning it is diminishing the deceased estate, meaning it is diminishing the inheritance of the beneficiaries. So it's good etiquette and practice to avoid any situations that can negatively impact the pocket of the beneficiaries to their estate. And by doing so, and in doing so, you ensure that you don't have any dramas about a will. Hence, you make sure there's only one will that is read, and it's in everyone's best interest, because if there's more, it is going to be a problem. It has to go to the court. The court has to make the final decision over what will is going to be taken and who's going to get what. And that costs money, and it obviously hurts the beneficiaries because it comes straight from the deceased estate. So that's why we do it. Does that make sense?
Yes, it does. Thank you so much.
Perfect, 100%. Right, next person, is it Claudia Camogelo? Okay, I'm not hearing anything from Claudia. So I'll go to the next name, Leratu.
Hello?
Hello.
Can you hear me? Yes, I'm here. My question is actually based on the interstate rule number 3 from yesterday's lecture. I think I lost you there when you were explaining about how when the one spouse dies with half, the kids are half sisters and half brothers. Can you please give me clarity on that one, sir?
Okay, just for my own clarity, am I speaking to Claudia or
My signal is a bit bad. It's Leratu.
Okay, fantastic. All right. So Leratu, so what happened is, remember, Rule 3 lives through Rule 2. So it says if you don't have a spouse and kids, next in line is your mother and father. So, but the rule says your mother's entitled to half and your father's entitled to half. So if you have R1 million, or let's make it easy. If you have 10 rand,
no, I think I made a mistake. I'm on that one for half sisters and half brothers.
Yes, I'm coming to that, but we've got to get our bases correct. So if you have 10 rand, you give 5 rand to your mom, 5 rand to your dad. All right. Now, next in line is the deceased brothers and sisters. And we said they inherit through each parent individually. Okay. So if you had a brother and a sister, and let's say...
Sorry, sir, I lost signal a bit there.
Okay. Leratu, can you hear me properly now?
I can hear you now.
Okay. All right. So just to make this easier, let's say there was 4 rand for your dad and 4 rand for your mom. All right. But let's say your mom has passed away. Okay. And you have, the deceased had a brother and a sister. We agree that the brother and the sister must now inherit from the mom's 4 rand, hey?
Mm-hmm.
So the brother must get 2 rand and the sister must get 2 rand. Nice and simple. All right. Now, remember, you can only inherit through blood. So let me say you have a brother and you have a sister, but you also have 2 half brothers. Okay. So if I say you have 2 half brothers, it means they either coming from your mom or they're coming from your dad. Hey, one of the two. They're not coming from both. So let's say I say you have 2 half brothers and they are from your father, for argument's sake. So your father went and, you know, made two other children with another woman.
Yes.
Now, in our scenario, we said our mother had passed away, and we said our brother and sister can inherit through our mother because they share blood. Those two half brothers in my example, if they came from the father, you agree they share no blood with my mom, right?
Yes, sir.
So does it make sense that they cannot inherit through my mom because they share no blood? So only my brother and sister can inherit through my mom. That's why I gave them each 2 rand, because there was only 4 rand. You happy with that?
Yes.
Okay, but let's turn it around. Let's say our mom is alive, but let's say our dad passed away. You agree that my brother and sister share blood with my dad, but you also agree that my 2 half brothers also share blood with my dad.
Yes.
So everyone can inherit through my dad. Only my brother and sister could inherit through my mom, but everyone can inherit through my dad. Okay. Now there was a second aspect to this rule. And the aspect was your half brothers and half sisters count as one person.
Yes, that's the aspect.
Yes. So I can't take that 4 rand and divide it 4 ways. I can't say here's 1 rand brother, here's 1 rand sister, here's 1 rand half brother, here's 1 rand half brother. I can't do that because the half brothers by law count as one person. So there's not 4 people, there's 3 people that I need to divide the money by. So if you take 4 rand and you divide it by 3, you'll see, let's say that's 1 rand 30 per person for argument's sake. So I go and I give 1 rand 30 to my brother, 1 rand 30 to my sister. And then I go and give the other 1 rand 30 to my 2 half brothers. So what does that mean? They're each going to get like 65 cents because they're going to share in that 1 rand 30. So your half brothers or half sisters, they inherit only through the parent that they were blood related with, and they count as one person. So they share in one person's share. We don't count them individually as people.
Oh, okay, I get it, sir.
Are you fine with that, Lerato?
Yes. And my second question is, why is it that maintenance is treated differently from inheritance when it comes to children, especially when it comes to adoption and marriage by if a child comes through marriage and it came from one spouse, but it's not the biological child for the other?
Right. So by law, you only have an obligation, a legal obligation towards your biological kids. You can take on an obligation towards kids that aren't yours. For example, let's say you marry someone else and they have a kid already. You can look after that kid. You can make it your obligation. But if you and that person's mother or father are no longer together, then your obligations fall away. You can't be forced to pay money or maintenance for someone who is not blood related to you, who's not your direct kid. The law only compels you to pay maintenance, well, obviously if you have a job, firstly, but only compels you to pay maintenance to your own direct blood kids. The only exception to that is if you adopt someone. If you adopt someone, then you also have a legal obligation to pay maintenance to them. So if it's not adopted, or if it's not your direct blood kids, the law does not put any legal obligation on you to pay maintenance towards them.
Oh, I get it also. My last question, thank you for that, sir. My last question is that if you have an antenuptial contract with accrual, and then the one spouse already has 1,000 in their estate, what happens if the spouse dies interstate?
And you were married with accrual?
Yes, antenuptial contract with accrual.
And that 1,000 rand came after your marriage?
That 1 million came prior to the marriage.
Oh, then you have no claim. Because if it's with accrual, you only share in what comes after date of marriage.
Yes. So what's going to happen with that 1 million rand, and then this spouse doesn't have kids? It's going to apply to rule 1.
Yeah, so rule 1 says, take the money and divide it between spouse and kids. Now, in your example, there is no kids, there's only a spouse, hey?
Mm-hmm.
Spouse is going to take everything then.
spouse is gonna take the 1 million rand even if they're married with accrual.
Yes, spouse will take everything because
But the 1 million rand was acquired before.
so remember, there's two elements. We have marriage and we have intestate law. So we start with marriage. Is the spouse entitled to that 1 million rand from the marriage? And the answer is no, because it came before, correct?
Mm-hmm.
Now we move on to intestate law. We look at rule 1. Rule 1 says divide the money between the spouse and kids. There's no kids, so there's no one to divide it with. The spouse will just take everything.
Oh, okay. Thank you so much, sir.
Perfect. You happy with that, Loratu?
I'm happy with your answer, sir. Thank you so much.
Okay. All right, ladies and gents, I think for one evening that's enough. I do see there's other hands. I'm just going to mention a couple names quickly. Lion, Obakeng, Lawazi, Angela, Becky Temba. I do see your hands. I will open the floor up for questions tomorrow, and if I forget, please remind me. But those hands I'm mentioning, you know, I must get to you tomorrow, and I will try and make a note that I make sure I assist you first when we do questions tomorrow. I obviously can't see everyone's hands, so I might have missed some names, but ladies and gents, what I will do and make a conscious effort of trying to do tomorrow night, I will try and first take questions from names I don't recognize, because obviously there's questions from you that I haven't had a chance to deal with. So we'll try to do that. And obviously, ladies and gents, if I have answered questions from you previously, don't stress. I will answer more and more from you in that regard. But as far as tonight goes, I think we made some good progress, ladies and gents. Tomorrow we move on and we'll have an opportunity for questions again. So from my end, have a good evening, everyone, and I'll see you and chat to all of you 5:30 tomorrow afternoon. Cheers.
Thank you so much, sir.
Thank you so much, sir.
Thank you.
Good night, guys.
For the second day, that's my question. Okay, good night.